Alright, welcome back. It's time for Civil Liberties and Civil Rights Unit 3, so let's do it. Alright, so this video is all about civil liberties and civil rights. Do me a favor real quick, make sure you hit that like button for me before you forget. Let's get right into it. Alright, so we're going to start with the 10 Amendments, the Bill of Rights. We know that the Bill of Rights was originally designed to limit the power of the federal government, to prevent it from taking away people's rights and personal freedoms. Specifically, we could look at the Bill of Rights as a list of protections of people's civil liberties. Civil liberties are guarantees of individual personal freedoms, things that every individual citizen enjoys a right to do. Alright, so the First Amendment, we have a few things we're going to focus on. We're going to start with religion. And we're going to actually break religion down into two things. We're going to have both the Establishment Clause and the Free Exercise Clause. So the Establishment Clause is the first part, where it says that Congress shall make no law concerning an establishment of religion. So in other words, Congress can't establish or say that the United States is a particular religion. This has also been interpreted to mean that Congress can't give preferential treatment for or against certain religions. Our required case that goes along with this is Engel versus Vitale, which says that states cannot sponsor public school prayer even if that prayer is voluntary, because this violates the Establishment Clause, because it is giving preference towards religion. Again, for all the details on not just that case, but all the cases we're going to touch on in this video, make sure you watch the individual videos or the Supreme Court review video to get all the details you need on those cases. The Free Exercise Clause is the next part of that sentence, and what this means is that Congress can't take away a person's right to practice their religion freely as they wish. And your required case that goes with this one is Wisconsin versus Yoder. And what the court ruled in this case was that compelling Amish families to send their students, their children, to school past 8th grade violated their free exercise rights, because they felt that going to school past 8th grade was going to be in conflict with the religious values that they were raising their children on. Next part of the First Amendment we want to turn our attention to is freedom of speech. And we have two free speech cases. Our first free speech case is Tinker versus Des Moines. And in this case, the Supreme Court ruled that you, students at school, you have freedom of speech. You are protected by the Bill of Rights even while you're at school. They also said that symbolic speech is a form of protected speech. So this is a good time to talk about some speech that is protected. Symbolic speech, so this could include things like wearing a black armband on your wrist, and it also includes things that are a little bit more controversial, such as burning the US flag. Those are both protected forms of speech, as they are considered symbolic speech. Another type of controversial speech that is also protected is hate speech. But there are limits. Now, it's important to note that the Constitution, the Bill of Rights, the First Amendment, does not provide any limit. It just says Congress shall make no law abridging the freedom of speech, and that's it. But, beginning with our next required case, Schenck versus the U.S., the Supreme Court did find that sometimes your free speech rights can be limited. Specifically, we can have time, place, and manner restrictions on speech. And so examples of speech that are not protected would include libel and slander. These are written and spoken lies about another person, obscenity, and words that are intended to incite imminent lawless action. So encouraging somebody to break the law, if it is expected to happen imminently, that can also be restricted. It is not a protected form of free speech. Now we go right into the freedom of the press, and we have a case for that, New York Times versus the U.S. And in this case, what the Supreme Court ruled is that there is a heavy presumption against government claims of prior restraint. Prior restraint means censorship. So in other words, it is extremely difficult for the federal government to ever prove that they are right in censoring or limiting the freedom of the press. Now, as we get to some other amendments, the Second Amendment has been interpreted very recently, only since 2008 in D.C. versus Heller, as guaranteeing an individual right to bear arms for the purpose of self-defense. And we're going to skip a few and go to the Eighth Amendment. You'll see why we come back to the others in a moment. The Eighth Amendment and its cruel and unusual punishment, it's important to note that the death penalty is still constitutional, but there have been some limits placed on it, such as based on age or mental deficiency of persons who will not be eligible to receive the death penalty. Alright, now we get to what is perhaps the most important concept in this unit. In fact, it is definitely the most important concept, and that is selective incorporation. All right, so based on the 14th Amendment and the Due Process Clause, which says, nor shall any state deprive any person of life, liberty, or property without due process of law, ... Based on that, the Supreme Court over the last 100 years has interpreted those words as meaning that now the Bill of Rights can also be seen as restricting state governments as well. So remember, originally, the Bill of Rights only protected people from the federal government. That is no longer true today. Because of selective incorporation, now states cannot take away your rights either that are found in the Bill of Rights. Now that word selective is very important because it means that this has been done on a case-by-case basis. So there is not a single moment in time where the entire Bill of Rights was incorporated and applied to the states. Alright, so speaking of incorporation, we have two selective incorporation cases. One is McDonald versus Chicago. We just talked about how there is an individual right to bear arms discovered in 2008. Well, in 2010, McDonald versus Chicago, that individual right to bear arms was incorporated. So state governments can no longer take away your right to bear arms. Guess what that means? Pre-2010, states could have done so. They no longer can because it's been incorporated. So states have clearly lost power, right? Because they are no longer able to do that. Something they could have done before that Supreme Court case, they no longer can do. Gideon versus Wainwright also is an incorporation case, and this incorporated the right to an attorney. So if a person can't afford one, we know that the Constitution, the Sixth Amendment, says that the government has to provide you with one. But in Gideon, this is what says that now state governments have to provide you with an attorney if you cannot afford one. All right, so speaking of the Fifth and Sixth Amendment, we have something known as your Miranda rights. This is the idea that a suspect, somebody being arrested, must be informed of their Fifth and Sixth Amendment rights. So we've all seen this on TV so many times, so we know that they have to tell you have the right to an attorney, that you have the right to remain silent, and if you can't afford an attorney, one will be provided for you, all that stuff. That's your Miranda rights. Again, it doesn't give you any new or additional rights, but it means you have to be informed of the rights that you do possess. Now, there is something known as the public safety exception, and this is the idea that if in that moment as that suspect is being arrested, if it is a dangerous situation where the public safety could be viewed as being in danger, the police can ask the suspect a question, and if that suspect voluntarily answers, that confession or that answer can be used against them in trial, even if they were not warned and told of their Miranda rights before the police asked that question. So you do have a limitation. So again, remember our context. We're thinking about the rights of the accused. The Miranda right supports the rights of the accused. The public safety exception kind of provides a narrowing of those rights of the accused and more of a pro-law enforcement, pro-government type of answer. Now, speaking of those rights of the accused, we have a list of pre-trial rights of the accused. The Fourth Amendment, we know, protects you against unreasonable searches and seizures, and this has been interpreted as protecting people from warrantless searches of cell phone data. So in order to look at and to review your cell phone data, police would need a warrant to be allowed to do so. And lastly, the Supreme Court has placed some limitations on the government's bulk collection of digital metadata. All right, last up in the civil liberties section is the right of privacy. Now, that wasn't mentioned in the Bill of Rights. It's not directly there. So this could be one of those unenumerated rights. The Supreme Court has found that you do have a right of privacy. And this is the basis for one of your required cases, Roe versus Wade, which famously said that states cannot ban abortion. Or said another way, it guaranteed that a woman has the right to obtain an abortion due to a right of privacy. Alright, so let's hit pause on the video right now, see this multiple choice question, answer it down below in the comments. Alright, and then when you're ready, move on and keep watching the rest of the video. Next, we want to think about civil rights. Now remember, civil liberties are talking about individual freedoms that we all have. Civil rights, on the other hand, these are protections from discrimination for groups of people. So this is talking about people being discriminated against on the basis of some group characteristic, and that could be race, it could be gender, it could be something else. But the idea is that civil rights are now government protections for people from discrimination. And the 14th Amendment, again, is important here. The Equal Protection Clause says that basically states cannot deny to any person within its jurisdiction the equal protection of the law. Now, that 14th Amendment and the Equal Protection Clause has been the basis for many social movements. So whether it's the civil rights movement of the 1950s and 1960s, or the women's rights movement, or the LGBTQ rights movement. We've seen a number of movements, and what they have in common is that they are asking for those words of the 14th Amendment to actually be fulfilled and to be guaranteed to protect their specific group that they are fighting for. Now, speaking of the civil rights movement, we have a required document. Again, check out that video, but it's the letter from Birmingham Jall. Martin Luther King Jr. beautifully writes on this issue and this topic, in which he demands the fulfillment of not only the 14th Amendment, but the Constitution as a whole, the preamble, the Declaration of Independence. But again, you see that inspiration from those founding documents on the social movement in the 1950s and the 1960s. Now, there was some great legislative success enjoyed by that movement. One example is the passage of the Civil Rights Act of 1964, which banned discrimination on the basis of a number of different things, including race, gender, color, national origin, and religion. And so it banned these in public accommodations and in employment. So when it comes to hiring or firing, as well as for any business that serves the public, they were no longer allowed to discriminate on the basis of any of those listed protected categories. Then we have the Voting Rights Act of 1965, which banned literacy tests and other obstacles to vote, along with the 24th Amendment banning the poll tax, led to a tremendous increase in minority voter turnout. So you see, again, success from that social movement. An earlier piece of success was found in Brown versus Board of Education, which required the desegregation of public schools. Now, we think about the women's rights movement. We have something called the National Organization of Women. This was an interest group that fought for women's rights, and they enjoyed success in the 1960s and 1970s. We have things like the Equal Pay Act, which did exactly what it sounded like. It guaranteed equal pay for equal work for women. We also have Title IX of the Educational Amendments, which prohibited discrimination on the basis of sex from any federally funded education program. And so again, we see a number of legislative successes as a result of a social movement. Lastly, we want to consider the Supreme Court and civil rights. At times, the Supreme Court has ruled in favor of civil rights and expanded rights to minorities, such as in Brown versus Board of Education, most famously, overturning Plessy and requiring the desegregation of public schools. At other times, however, the Supreme Court has limited the rights of the minority and ruled in favor of the majority. So Plessy versus Ferguson, allowing Jim Crow laws and separate but equal segregation. And then in Shaw versus Reno, we have where the Supreme Court struck down racial gerrymandering, even though the district was being drawn to increase minority representation. So the court here ruled in favor of a colorblind interpretation of the Constitution, which prohibits any distinction based on race, even if it's to help minority interests in the case of redistricting. Now, affirmative action, on the other hand, allows for preferential hiring and admissions policies for minorities to expand minority opportunity, and currently this still is legally allowed in the United States, although we do have Supreme Court cases coming up, and so again, this shows that this type of thing could change very quickly over time. Alright, so that's it for this video. Make sure you stick around until next time. This has been a LaMoney production. Thanks again for watching this video. Make sure you hit that like button for me, subscribe if you haven't already, and make sure you check out the Ultimate Review Pack. It is helping so many students prepare and ace this AP exam. I wanted to help you out too, so click in the link down below. See you guys next time.